The cement mixer's drum rotated lazily in my driveway that Tuesday morning when I noticed the woman marching toward my property with a clipboard clutched against her chest like a shield. And I knew immediately this was going to be trouble. I wiped the concrete dust from my hands onto my jeans and squinted against the Arizona sun beating down on my Scottsdale neighborhood. The woman approaching was maybe 45, with that particular haircut that screamed management tendencies, the kind where the back is shorter than the front, and dyed an aggressive shade of blonde with dark roots showing. "Excuse me," she called out while still 15 feet away, her voice sharp enough to cut through the mixer's mechanical rumble. "You need to turn that off immediately." I reached over and hit the kill switch, letting the sudden silence speak for itself before I responded. "Can I help you?" "I'm Patricia Carmichael, president of the Sunset Ridge HOA." She thrust the clipboard forward like it was a legal document I needed to sign right that second. "And that," she pointed at my cement mixer with a manicured nail painted the color of dried blood, "is a direct violation of our community standards." I looked at my mixer, then back at her. "It's a tool. I'm doing some work on my property." Section 12, Paragraph 4 of the HOA bylaws clearly states that commercial equipment cannot be operated on residential properties. Patricia's lips pressed into a thin line of satisfaction, like she had just delivered a winning argument in court. Commercial equipment. I let out a short laugh. "Lady, you can buy one of these at any hardware store. It's a cement mixer, not a bulldozer. The noise level alone constitutes a disturbance to the peaceful enjoyment of the neighborhood." She tapped her clipboard with that blood-red nail. "I'm issuing you a formal warning. If you continue to operate this equipment, the HOA will begin fining procedures, $50 per day, escalating to $200 after the first week." I crossed my arms and leaned against my truck. "You know what, Patricia? I don't think you want to go down this road." "Is that a threat?" Her eyes widened with the kind of excitement people like her get when they think they have caught someone doing something wrong. "It's advice, free advice, which is more than your HOA has ever given me." Patricia straightened her spine, somehow gaining an extra inch of height through pure indignation. "The HOA exists to protect property values and maintain community standards. If you have a problem with that, perhaps you should consider relocating to a less refined area." "Less refined," I repeated, tasting the words. "That's interesting coming from someone standing on my concrete." She blinked, confused. "Excuse me, never mind." I waved my hand dismissively. "When do you need this mythical violation corrected by?" "Immediately." "The mixer must be removed from the property or stored out of sight by end of business today." She pulled a yellow carbon copy form from her clipboard and held it out to me. "This is your official notice." I took the paper, glanced at it, and folded it into my back pocket. "I'll take it under advisement. This isn't optional, Mr." She consulted her clipboard. Yates Donovan." I extended my hand, which she ignored. "Mr. Donovan, the HOA has the authority to place liens on your property if you fail to comply with community standards. I suggest you take this seriously." After she left, I stood in my driveway for a long moment, staring at the mixer. It was small as far as these things go, barely making more noise than a lawn mower. But that wasn't really what this was about. Patricia Carmichael had probably been driving past, seen something that looked vaguely industrial, and decided it offended her sense of suburban order. What she didn't know, what none of them knew, was that I wasn't just some random homeowner she could push around with threats and fines. I was Yates Donovan, and my grandfather had been Earl Donovan, and Earl Donovan had owned Donovan Concrete and Supply, the company that had poured every single foundation, driveway, sidewalk, and patio slab in the entire Sunset Ridge development back in 2003. More importantly, my grandfather had been smart. Really smart. I pulled out my phone and dialed my lawyer, Marcus Chen, who had handled my family's business affairs since my grandfather passed 5 years ago. "Yates, what's up?" Marcus answered on the second ring, the sound of traffic in the background suggesting he was driving. "HOA's trying to ban my cement mixer, threatening fines. Can't you just put it in the garage?" "That's not the point, Marcus. They're coming at me with this attitude like they own the place." "Technically, they kind of do govern the place." "Actually," I said, walking toward my house, "that's why I'm calling. I need you to pull out all the paperwork from the Sunset Ridge development. Everything. The original contracts, the easements, all of it." There was a pause. "Why do I feel like you're about to start a war?" "Not starting anything. Just reminding some people about how things really work." Marcus sighed. "I'll have my paralegal dig it out. Give me a day or two. Make it one day. They want compliance by end of business today." "Yates, don't do anything stupid." "Would I do that?" "Yes. Literally yes, you would." I hung up and went inside where my girlfriend Wendy was working at the kitchen table, her laptop open and papers spread around her in organized chaos. She was a project manager for a tech company, which meant she understood bureaucracy and how to navigate it better than most people. "Who was that marching up like she owned the place?" Wendy asked without looking up from her screen. "HOA president. Wants me to get rid of the mixer." Now she looked up, her dark eyes curious. "The little one you bought to fix the back patio, that's the one. Apparently it's commercial equipment that violates community standards." Wendy closed her laptop. "Are you going to fight this? Because I know that look." "What look?" "The look that says you're about to make someone regret their life choices." I grinned. "I'm going to educate them. There's a difference." "Uh-huh." She stood and walked over to the coffee maker. "What's your play?" "Remember how I told you my grandfather poured all the concrete for this neighborhood?" "Yeah, you mentioned it when we first looked at the house." "What I didn't mention is that he was smart about it. Really smart. He put provisions in the original development contracts that protected his company's interests." Wendy poured herself a cup and leaned against the counter. "What kind of provisions?" "The kind that means this HOA doesn't have quite as much power as they think they do." The next day, Marcus called me at 8 in the morning. "Okay, I went through everything. Your grandfather was either paranoid or brilliant." "Both, probably. What did you find?" "Do you want the legal version or the version that will make sense?" "Make sense version." "All right. So back in 2003, when this development was being planned, your grandfather's company signed on to do all the concrete work. But he didn't just sign a simple contractor agreement. He negotiated an easement and maintenance agreement that was recorded with the county and referenced in every single deed for every single property in Sunset Ridge." I sat down at my kitchen table, phone pressed to my ear. "Keep going." "The agreement states that Donovan Concrete and Supply retains perpetual easement rights for maintenance, repair, and inspection of all concrete installations throughout the development. Furthermore, it specifies that any attempt to restrict the company's access or ability to perform said maintenance would constitute a material breach of the development's foundational agreements." In English, Marcus. In English. "Your grandfather basically made sure that he and his company could come and go as they pleased to work on any concrete in the neighborhood, and nobody could stop him. And since you inherited the company when he passed, those rights transferred to you." I felt a smile spreading across my face. "So if I need to use a cement mixer to maintain the concrete, then the HOA can't do anything about it. In fact, if they try to restrict your access or your equipment, they would be in violation of the easement agreement, which could potentially void their authority over certain aspects of the development. Could void their authority? Well, it's complicated. The HOA was established after your grandfather's agreement was recorded. Technically, his agreement takes precedence because it's part of the foundational deed restrictions. But an HOA's power comes from a different set of recorded documents. Where it gets interesting is that the HOA's authority is limited by pre-existing easements and agreements. Your grandfather's easement is pre-existing. So what you're saying is, my rights supersede theirs. In this specific matter, yes, but Yates, here's where you need to be careful. If you push this too hard, they could argue that you're not actually doing maintenance work, that you're just using the easement as an excuse to ignore their rules. Then I'll do maintenance work. What? There's plenty of concrete in this neighborhood that could use some attention. The sidewalk on Crimson Drive has cracks. Some of the driveways are settling. I'll be performing my duties under the easement agreement. Marcus was quiet for a moment. You're really going to do this? They came to my house, Marcus. They threatened me with fines and liens because I was using a small cement mixer in my own driveway. Yeah, I'm really going to do this. All right. I'll draft a formal response to their notice, citing the easement agreement and your rights under it. But Yates, this is probably going to escalate. Let it escalate. 2 days later, I received a certified letter from the Sunset Ridge HOA. It was 5 pages long, filled with legal-sounding language about violations, compliance requirements, and the escalating fine schedule. At the bottom, Patricia Carmichael had signed her name with a flourish that took up 3 lines. I read it twice, then called Marcus. They're doubling down. I sent them our response yesterday. They must have already had this in the works. It says here I have 72 hours to comply or face a special hearing before the HOA board, followed by immediate fines and potential legal action. You want me to handle this? Or are you going to go in there yourself? I thought about it. When's the hearing? According to their letter, Monday night at 7. That gives you 4 days. I'll handle it, but I want you there as backup. This is going to cost you, you know. I know, bill me. That weekend, I loaded up my truck with the cement mixer, bags of concrete, tools, and everything else I would need. Then I drove slowly through Sunset Ridge, making notes of every crack, every settling slab, every piece of concrete that showed even minor wear. There was a lot of it. 22 years of Arizona sun and occasional rain had not been kind to the development's concrete work. Most of it was still structurally sound, but cosmetically, there were issues everywhere. Nothing dangerous, but definitely things that could be classified as maintenance needs. On Sunday, I started work on the sidewalk along Crimson Drive. I set up my cement mixer in the street, put out safety cones, and began cutting out a section of cracked concrete. The mixer's drum turned rhythmically as I mixed a fresh batch, the sound carrying through the quiet suburban morning. Patricia Carmichael appeared within 30 minutes. What do you think you're doing? She was wearing workout clothes, suggesting I had interrupted her morning routine. Maintenance work. That section was cracked and posed a potential liability. I didn't stop working, spreading the fresh concrete into the form I had built. You can't just start construction in the middle of the street. It's not construction, it's maintenance. And according to my easement agreement with this development, I not only can, I have the responsibility to. Your easement agreement, she pulled out her phone. I don't know what you're talking about. You're just a homeowner here, same as everyone else. Actually, Patricia, I'm a homeowner and the owner of Donovan Concrete and Supply, which holds perpetual easement rights throughout this entire development. You would know that if you had bothered to check the deed restrictions before you started throwing around threats. Her face flushed. That's ridiculous. I would know about something like that. Would you? When did you move into the neighborhood? 3 years ago, but I've been HOA president for 2 years and I've reviewed all the relevant documents. Did you check the county records? Because that's where the easement is recorded. It was filed in 2003, before most of these houses were even built. Patricia's eyes narrowed. You're making this up. I pulled out my phone, called up the PDF Marcus had sent me, and held it out to her. Feel free to read it. It's public record. She snatched the phone from my hand and started scrolling, her expression growing darker with each passing second. This doesn't mean you can just ignore HOA rules. Actually, it kind of does, at least when it comes to concrete maintenance and the equipment required to perform that maintenance. We'll see about that. The board meeting is tomorrow night. You can explain yourself there. She shoved my phone back at me and stormed off, pulling out her own phone before she had even made it back to her house. I finished the sidewalk repair, cleaned up my equipment, and went home satisfied. Wendy was in the backyard, reading on the patio I had been planning to expand. How'd it go? She asked. Patricia showed up. She's not happy. I heard the mixer. I'm surprised it took her that long to get there. She threatened me with tomorrow's board meeting. Wendy set down her book. Are you sure you want to do this? We live here. If you burn bridges with the HOA, it's going to make everything harder. They started this, not me. I was just trying to fix our patio. I know, but there's a difference between being right and being smart about it. I sat down next to her. What would you do? Honestly, I'd probably let you fight this battle because you're better at confrontation than I am. But I'd also remind you that sometimes winning the war means losing a few battles gracefully. You think I should back down? I think you should decide what you actually want out of this. Do you want to be able to use your cement mixer? Do you want to put the HOA in their place? Do you want to make sure they never bother you again? Because those are different goals with different approaches. I thought about it while watching the clouds drift across the sky. I want them to understand they can't just push people around because they have a clipboard and a title. Then educate them tomorrow, but do it in a way that doesn't make you the villain. The Sunset Ridge HOA board meeting was held in the community center, a low-slung building near the development's entrance that also housed a small gym and pool. I arrived 15 minutes early with Marcus, who was carrying a leather briefcase that probably cost more than my truck. Remember, Marcus said as we walked in, let me do most of the talking. You're the sympathetic homeowner trying to improve his property, not the guy looking for a fight. I'm not looking for a fight. Yes, you are, but we're going to pretend you're not. The meeting room had about 30 chairs set up facing a long table where 5 board members sat. Patricia was in the center, flanked by 2 men and 2 women I vaguely recognized from around the neighborhood. Maybe a dozen other residents were scattered through the audience chairs, probably there for other agenda items. Patricia called the meeting to order at 7 sharp, working through the standard administrative items with practiced efficiency. Pool maintenance, landscape contracts, budget reviews. Finally, after 20 minutes, she reached my issue. Item 7. Violation enforcement regarding 4282 Sage Court, resident Yates Donovan. She looked directly at me. Mr. Donovan, you were issued a notice of violation regarding operation of commercial equipment on residential property. Rather than comply, you've instead begun conducting unauthorized construction throughout the development. Would you care to explain? I started to stand, but Marcus put a hand on my arm. He stood instead. Marcus Chen, representing Mr. Donovan. For the record, my client has neither operated commercial equipment nor conducted unauthorized construction. What he has done is perform routine maintenance work, in accordance with a recorded easement agreement that predates this HOA's establishment. One of the board members, a heavy-set man in his 50s, leaned forward. "What easement agreement?" Marcus opened his briefcase and pulled out a stack of documents. "I have copies for each board member and for the record." "This is the concrete maintenance and access easement agreement recorded with Maricopa County on August 15, 2003, between Donovan Concrete and Supply and Sunset Ridge Development, LLC. It grants perpetual rights to the concrete contractor for maintenance, repair, and inspection of all concrete installations throughout the development." He distributed the documents while continuing. "Mr. Donovan's grandfather, Earl Donovan, owned Donovan Concrete and Supply and personally oversaw all concrete work during the development's construction. When he passed in 2020, the company and all associated rights transferred to Mr. Donovan. Those rights include unrestricted access for maintenance purposes and the use of any equipment reasonably necessary to perform such maintenance." Patricia was reading the document, her face growing increasingly red. "This is absurd. You can't just claim some ancient easement gives you the right to ignore community standards. It's not ancient, it's part of your deed restrictions," Marcus replied calmly. "Every property owner in Sunset Ridge purchased their home subject to this easement. It's referenced in the title work for every single deed." Another board member, a woman with gray hair pulled back in a bun, raised her hand. "I'm confused. Are you saying Mr. Donovan can do whatever he wants?" "No, madam. I'm saying Mr. Donovan has the right to perform concrete maintenance and repairs throughout the development, and to use standard industry equipment to do so. That includes cement mixers, concrete saws, and other tools necessary for the work. The HOA cannot restrict these activities because they're protected by a recorded easement that takes precedence over HOA rules." "But he was just mixing concrete in his driveway," Patricia protested. "That wasn't maintenance for the community." I stood up this time before Marcus could stop me. "Actually, I was mixing concrete to repair and expand my patio, which was installed by my grandfather's company in 2003. The original installation is showing its age, and as the easement holder, I have both the right and the responsibility to maintain it properly." "Your personal patio isn't community property," Patricia shot back. "No, but the concrete is still subject to the easement. And more importantly, the sidewalk I repaired on Crimson Drive definitely is community property, as are the 15 other locations throughout the development that need attention." The heavyset man flipped through the easement document. "It says here the easement holder is required to maintain the concrete installations. Required, not permitted. Is that correct?" Marcus nodded. "Yes, sir." "The agreement includes an indemnification clause that protects the development from liability related to concrete failure or defects. But in exchange, it requires the easement holder to perform reasonable maintenance." "So you're saying we can't stop him because if we do, we lose our liability protection?" "Essentially, yes. The agreement is reciprocal. Mr. Donovan maintains the concrete and the development is protected from lawsuits related to concrete issues." Patricia slammed her hand on the table. "This is ridiculous. He's clearly just using this as an excuse to do whatever he wants. I move that we reject this easement claim and proceed with violation enforcement." "You can't reject it," Marcus said. "It's a recorded legal document. You can no more reject it than you can reject the property boundaries or utility easements. Then we'll challenge it in court." "That's certainly your right, but I should mention that attempting to restrict a valid easement could expose the HOA to legal liability. My client would have grounds to sue for interference with his property rights." The board members looked at each other, clearly uncertain. The woman with gray hair spoke up. "Can we table this pending review by the HOA attorney?" "Motion to table," said the heavy-set man. "Second," said another board member. Patricia looked furious but had no choice. All in favor, 4 hands went up. Only Patricia abstained. Motion passes. This matter is tabled pending legal review. She glared at me. Meeting adjourned. Outside, Marcus and I walked back to our cars in the dark parking lot. "That went better than expected," he said. "Patricia's going to push this." "Oh, definitely. She's going to hire a lawyer, they're going to review everything, and eventually they're going to realize I'm right. But that could take months. And in the meantime, you can operate your cement mixer and do your maintenance work. They can't enforce violations while the matter is under review, not without exposing themselves to liability." I shook Marcus's hand. "Thanks for having my back." "That's what you pay me for. But Yates, seriously, be smart about this. Don't antagonize them more than necessary." "I'll be a model of restraint." Somehow I doubt that. Over the next 3 weeks, I worked on concrete projects throughout Sunset Ridge. I repaired the sidewalk cracks, fixed settling driveway slabs, patched pool deck damage. Each time I set up my equipment professionally, used proper safety measures, and worked during reasonable hours. I wasn't trying to annoy anyone, just making a point while doing actually useful work. Most of my neighbors appreciated it. Several stopped to thank me for fixing problems they had noticed, but assumed would never get addressed. A few even asked if I could do some work on their personal driveways or patios, and I gave them quotes for the work. But Patricia Carmichael was not appreciative. She documented everything I did, took photos, filed additional violation notices that Marcus responded to with citations of the easement agreement. She rallied other board members, held special meetings, and generally made the whole thing her personal crusade. Then one morning, I received a new certified letter. This one wasn't from the HOA directly, but from a law firm in Phoenix, Whitmore and Associates. The letter informed me that the HOA was initiating legal action to invalidate the easement agreement on the grounds that it was overly broad, improperly recorded, and contrary to public policy. They were seeking a declaratory judgment that would limit the easement to only emergency repairs requiring board approval, and they were also seeking damages for my unauthorized construction activities. I called Marcus immediately. "Yeah, I got served with the same complaint this morning," he said. "They're serious. Can they win? Honestly, no, probably not, but they can make this expensive and time-consuming. Are you sure you want to fight a protracted legal battle over a cement mixer?" I thought about Wendy's question from weeks earlier. What did I actually want out of this? "Marcus, can I ask you something? If we win this case, what happens? Best case scenario. The court affirms your easement rights, orders the HOA to stop interfering, maybe awards you attorney fees if we can prove their case was frivolous. And worst case, the court narrows the easement somehow, limits when and how you can exercise it, but I don't see them invalidating it entirely. The document is solid. So either way, this ends up in front of a judge. Eventually, yes, unless they drop it or we settle. Then let's countersue. For what? Harassment. Interference with property rights, whatever applies. If they want a legal battle, let's give them one." Marcus sighed. "I was afraid you'd say that. All right, I'll draft a counterclaim. But Yates, this is going to get expensive." "I know. Do it anyway." The legal battle consumed the next 4 months. Depositions, discovery, motions, and more paperwork than I had seen in my entire life. Marcus had to bring in a junior associate just to handle all the document review. The HOA's attorney, a sharp woman named Rebecca Whitmore, argued that the easement was essentially a private contract that couldn't supersede the HOA's legitimate authority to regulate the community. She brought in an expert witness who testified that cement mixers constituted industrial equipment inappropriate for residential areas. Marcus countered with the recorded nature of the easement, showing how it was part of the title chain for every property. He brought in his own expert who testified that small cement mixers were standard equipment for residential concrete work. He also deposed Patricia Carmichael, which apparently did not go well for the HOA's case. "She's a terrible witness," Marcus told me after the deposition. "She kept going off on tangents about community standards and property values, but when I asked her specific questions about the legal basis for their restrictions, she had nothing. So we're winning. We're not losing. But judges don't like HOA disputes. They're going to push us toward settlement." He was right. In month 5, Judge Sarah Delgado called both sides into her chambers for a settlement conference. "I've reviewed the pleadings and the easement agreement," she said, looking between Marcus and Rebecca Whitmore over her reading glasses. "Miss Whitmore, I have to tell you your client's position is weak. This is a properly recorded easement with clear, unambiguous language. Your Honor, the easement may be valid, but my client contends that Mr. Donovan is abusing it to avoid legitimate HOA oversight," Rebecca argued. "Is he?" "Mr. Chen, what work has your client actually performed?" Marcus pulled out a folder. "Sidewalk repairs, driveway leveling, pool deck patching, all legitimate maintenance work on concrete installations. We have before and after photos, material receipts, and testimony from several residents expressing appreciation for the improvements." Judge Delgado looked at Rebecca. "So he's actually maintaining the concrete?" "Well, yes, but then what's the problem? The easement says he's supposed to maintain the concrete. He's maintaining the concrete. Where's the abuse? The noise, Your Honor, the disruption to the peaceful enjoyment of the community. Surely those are legitimate concerns for an HOA. Are we talking about reasonable hours? Is he working at night, on weekends?" Marcus shook his head. "Monday through Friday, 9 to 5. Occasionally Saturdays in the morning, but never before 9 a.m. and never past noon. Those seem like reasonable hours for construction work," the judge said. "Miss Whitmore, I'm inclined to grant summary judgment for the defendant on the primary issue. The easement is valid and Mr. Donovan has the right to perform maintenance work. However, I think there's room for compromise on the specifics." "What kind of compromise?" I asked, earning a look from Marcus. Judge Delgado addressed me directly. "Mr. Donovan, you need to use your cement mixer every single day." "No, madam. I use it when I have concrete work to do. Sometimes that's several days in a row, sometimes it's just one day every few weeks." "And would you be willing to provide the HOA with advance notice before you begin work? Not asking permission, just informing them." I glanced at Marcus, who gave a slight nod. "Yes, Your Honor, I'd be fine with that." "Miss Whitmore, would a notification requirement satisfy your client's concerns about disruption?" Rebecca conferred quietly with Patricia Carmichael, who had been sitting in the corner looking progressively more frustrated throughout the conference. "Your Honor, my client wants restrictions on the hours, the frequency, and the duration of any work. Your client wants to turn a valid easement into a permission-based system," Judge Delgado said flatly. "That's not going to happen. Here's my suggestion, and I strongly encourage both parties to accept it. Mr. Donovan will provide 48 hours written notice to the HOA before beginning any maintenance work. The notice will include the location, expected duration, and general scope of work. The HOA cannot deny or restrict the work, but they can coordinate with Mr. Donovan on timing if there are legitimate scheduling conflicts like community events. Mr. Donovan agrees to work during reasonable hours, which I'll define as weekdays between 8 a.m. and 6 p.m., and Saturdays between 9 a.m. and 3 p.m. No work on Sundays or major holidays. In exchange, the HOA drops all violation notices, fines, and legal claims. Mr. Donovan drops his counterclaim. Both sides pay their own attorney fees. Your Honor, that doesn't address the fundamental issue. Patricia started, but Rebecca cut her off. Can we have a few minutes to discuss? Judge Delgado checked her watch. You have 10 minutes. Use them wisely. Marcus and I stepped outside the chambers while the HOA contingent huddled in the corner. What do you think? I asked. I think it's a reasonable compromise. You get to keep your rights, they get some predictability. Neither side pays the other's legal fees, which saves you probably 20 grand. I wanted them to pay. Yates, judges almost never award fees in HOA disputes unless someone did something truly egregious. Take the win. When we reconvened, Rebecca spoke first. My client has concerns about leaving the easement unrestricted, but we're willing to accept the court's proposal with one modification. Mr. Donovan agrees not to perform work in front of any individual property more than once per calendar quarter without that homeowner's express permission. Marcus looked at me and I nodded. Agreed, with the understanding that emergency repairs aren't subject to that restriction. Acceptable, Rebecca said. Judge Delgado smiled. Excellent. I'll have my clerk draft an order incorporating these terms. Gentlemen, ladies, let me give you some advice. This whole dispute has been about pride and control, not about any actual harm. Mr. Donovan, you have legitimate rights, but don't be a jerk about exercising them. Miss Carmichael, your HOA exists to serve the community, not to micromanage every aspect of people's lives. Now please go home and find something more productive to do with your time. We filed out of the courthouse into the Phoenix heat. Patricia Carmichael walked past me without a word, her face stiff with suppressed anger. Rebecca Whitmore, however, stopped. Between you and me, she said quietly, you had a solid case. My client didn't want to hear it, but that easement is bulletproof. For what it's worth, the work you've done in the neighborhood looks good. Several of my client's board members have privately acknowledged it's an improvement. Thanks, I said. Tell Patricia I'm not the enemy. I don't think she's ready to hear that yet. Give it time. 2 weeks later, the court order was finalized and recorded. I had my rights confirmed, the HOA had their notice requirement, and everyone could move on with their lives. Except Patricia Carmichael apparently couldn't let it go. It started with small things. My garbage cans were left at the curb on a Wednesday afternoon, and I received a violation notice. Never mind that trash pickup had been delayed due to a broken truck, and the waste company had asked residents to leave cans out. Patricia photographed my bins and filed the complaint anyway. Then she noted that my front yard grass was 1/4 inch above the maximum height specified in the landscaping guidelines. I measured it myself with a ruler. It was exactly at the maximum height, not above it. She documented my truck being parked on the street overnight, even though I was loading equipment, and there was no rule against overnight street parking for residents. Every petty violation she could dream up, she filed. And every one of them, Marcus had to respond to, costing me time and money. She's harassing you, Marcus said during one of our increasingly frequent phone calls. This is textbook retaliation. Can we do anything about it? Document everything. Keep copies of all her complaints and our responses. If it continues, we can go back to Judge Delgado and ask for a restraining order or an injunction. But before it got to that point, something unexpected happened. I was working on a Saturday morning in early November, repairing a section of sidewalk on Desert Vista Lane when a man in his 70s approached me. He was wearing khaki pants and a polo shirt, walking with a slight limp. "You're Yates Donovan?" he asked. "That's me. I'm Howard Price. I live over on Cactus Court." He extended his hand and I shook it, concrete dust and all. "I wanted to thank you for the work you've been doing. My driveway was settling on one side and you leveled it out last month. First time in 3 years I haven't had water pooling there after rain." "Just doing maintenance," I said. "Glad it helped. Listen, I know Patricia has been giving you hell. I'm on the HOA board and I want you to know not all of us agree with her approach. I appreciate that. More than that, I want you to know there's going to be a vote at the next board meeting. Several of us have had enough of her antics. We're going to remove her as president." I stopped working and looked at him. Because of me. Because of how she's handled this whole situation. "You weren't the first person she's gone after. Just the first one who had the resources and legal standing to fight back. But she's created a toxic environment on the board and in the community. People are afraid to put out their trash or let their grass grow a normal length because they're worried about getting violation notices. That's not what an HOA is supposed to be." "What is it supposed to be?" Howard smiled. "That's what we're hoping to figure out. But first, we need to make a change. I wanted to give you a heads up in case Patricia tries to blame you for it. I can handle Patricia. I believe you can. But be careful anyway. She doesn't strike me as someone who handles rejection well." The next HOA board meeting was on a Tuesday night, and I didn't attend. Marcus had advised me to stay away, to let the board handle their internal politics without my involvement. But Wendy went, curious to see what would happen. She came home at 9:30, shaking her head in amazement. "It was brutal," she said, dropping onto the couch. "Howard Price made a motion to remove Patricia as president, citing conduct unbecoming the position and failure to act in the community's best interests. The vote was 4-1, with Patricia as the only no vote. How did she take it? She screamed at them, called them traitors and idiots, said the neighborhood would fall apart without her leadership. Then she stormed out and slammed the door so hard one of the pictures fell off the wall. Did they elect a new president? Howard. He seems reasonable. His first act was to direct the board to stop all pending violation proceedings that he called frivolous. He specifically mentioned your garbage can situation. I felt a weight lift that I hadn't realized I'd been carrying. So it's over. With the board, maybe. With Patricia, Wendy shrugged. I don't know. She looked pretty unhinged when she left. 3 days later, I found out exactly how unhinged. I was at my house working on expanding the back patio, the cement mixer humming away, when I heard shouting from the front yard. I walked around the house to find Patricia Carmichael standing in my driveway, holding a sledgehammer. "Patricia, what are you doing? You ruined everything." She was crying, mascara running down her face. "I dedicated 2 years to making this community better, and you destroyed it in 6 months." "I didn't destroy anything. I just fixed some concrete. You humiliated me. You made me look like a fool in front of the judge, in front of the board, in front of everyone." She hefted the sledgehammer. "Well, if you can destroy my reputation, I can destroy your work." She swung the hammer down toward my freshly poured sidewalk section from last week. I lunged forward and caught the handle before it connected. "Patricia, stop. You're going to hurt yourself or damage property. This is insane." She tried to pull the hammer away from me, but I was stronger. We struggled for a moment before I wrenched it out of her hands and tossed it across the yard. "Get off my property," I said firmly. "Right now. You don't own this. Your grandfather maybe poured it, but it belongs to the community." She was hysterical now, completely irrational. Wendy appeared in the doorway. Yates, I called the police. You can't have me arrested. I'm the HOA president, former president, I corrected. And yes, we can, because you just came onto my property with a weapon and attempted to destroy things. 2 Scottsdale police officers arrived within minutes. Patricia tried to explain to them about HOA violations and community standards and her righteous crusade to maintain property values, but they weren't interested in the politics. What they saw was a woman who had brought a sledgehammer onto someone's property without permission and attempted to damage things. They arrested her for criminal trespassing and attempted criminal damage. As they led her to the patrol car, she was still yelling about easements and violations and concrete. One of the officers came back to take my statement. "Has she been harassing you?" he asked. "For months. I have documentation if you need it. You might want to get a restraining order." This kind of fixation doesn't usually just go away. "I'll talk to my lawyer." After they left, Wendy and I sat on the front step. "That was terrifying," she said. "She's unraveling. I almost feel bad for her." "Don't. She did this to herself. All you did was stand up for your rights." Marcus helped me file for a restraining order, which was granted after Patricia failed to appear at the hearing. According to Howard Price, she had moved out of Sunset Ridge entirely, selling her house to the first buyer who made an offer and relocating somewhere in California. The new HOA board, under Howard's leadership, took a completely different approach. They focused on actual community concerns like maintaining common areas, organizing neighborhood events, and handling legitimate disputes between neighbors. They stopped the aggressive violation enforcement that had characterized Patricia's tenure. Howard even approached me about formalizing a maintenance schedule for all the concrete throughout the development. "If you're going to be doing this work anyway, we might as well coordinate it properly," he said. "We could set aside some budget to help with materials for community areas." I agreed, and we worked out a reasonable plan. Twice a year, I would do a walkthrough of the entire development, noting any concrete that needed attention. I'd prioritize safety issues, then cosmetic problems. The HOA would cover materials costs for repairs to common areas, and I'd charge a reasonable labor rate that was less than they would pay an outside contractor. It worked out well for everyone. The neighborhood's concrete stayed in good condition. I had steady work that I could schedule around other projects, and the HOA saved money compared to hiring contractors for every little repair. More importantly, I could use my cement mixer whenever I needed it, and nobody sent me threatening letters about violations. One Saturday afternoon in March, almost a year after Patricia had first marched up to my driveway with her clipboard, I was finishing up a repair on Desert Vista Lane when a young couple approached me. They were maybe 30, pushing a stroller with a sleeping baby inside. "Excuse me," the woman said. "Are you Yates Donovan?" "That's me. We just bought the house on the corner last month. We've heard about you from the neighbors. Good things, I hope." "Definitely. Everyone says you've made such a difference in how the neighborhood looks and feels." We actually chose this development partly because of the well-maintained infrastructure. Her husband nodded. "We looked at a lot of places, and most of them had cracked sidewalks and settling driveways. This place looks almost new, even though we know it's over 20 years old." "That's kind of you to say. It's just concrete." "Maybe," the woman said, "but it's also someone who cares enough to maintain things properly. That makes a difference." After they walked away, I packed up my tools and stood looking at the street. She was right in a way. It wasn't really about the concrete, and it never had been. It was about someone thinking they had the power to tell me what I could or couldn't do on my own property, without bothering to understand the situation or consider whether their rules even made sense. My grandfather had understood something important when he negotiated that easement agreement back in 2003. He had understood that real power doesn't come from a title or a clipboard or the ability to find people. Real power comes from owning something essential, from being the person who knows how to build things that last. Every house in Sunset Ridge, every driveway, every sidewalk and patio and pool deck sat on concrete that my grandfather had poured. Patricia Carmichael had thought she ran the neighborhood because she was HOA president, but the truth was that she and everyone else in the development were literally living on top of my family's work. And now, when I drove through those streets with my cement mixer in the truck bed, I wasn't just some homeowner who had won a legal battle. I was carrying on my grandfather's legacy, maintaining what he had built, making sure it would last for another 20 years and beyond. That evening, Wendy and I sat on our newly expanded patio, drinking beer and watching the sunset paint the sky orange and purple. "You know what's funny?" she said. "All of this started because Patricia saw your little cement mixer and decided it offended her sense of order. It's not even that loud. You can barely hear it from the street. That's my point. If she had just ignored it or politely asked you to put it in the garage when you weren't using it, none of this would have happened. Instead, she tried to flex her authority and ended up losing everything." "You think I should have handled it differently?" Wendy considered the question. "No, you stood up for yourself in a reasonable way. You didn't start anything, you just refused to back down when someone tried to bully you. That's different." "Marcus probably wishes I had just moved the mixer and avoided the whole legal battle. Marcus got paid very well to handle that legal battle. I'm sure he's fine with how it turned out." I laughed. "Fair point." We sat in comfortable silence for a while, listening to the evening sounds of the neighborhood. Kids playing in yards, dogs barking, someone's music drifting from an open window. Normal suburban sounds, the kind that meant people were living their lives without fear of violation notices. "Do you ever think about what your grandfather would say about all this?" Wendy asked. "Probably that I made it more complicated than it needed to be. He was better at dealing with people than I am. I don't know. He's the one who put that easement in the contract in the first place. He must have known there might come a time when it mattered." She was right. My grandfather had been planning for exactly this kind of situation, even if he couldn't have predicted the specific details. He had made sure that no matter what happened, no matter who tried to exert control over the development, his company and his family would have the final say on anything related to concrete. It was a gift, really. Not just the legal protection, but the reminder that sometimes the best way to win is to build something so essential that nobody can afford to be your enemy. Howard Price called me a few weeks later. "Yates, I've got a situation I wanted to run past you. The board has been talking about some larger projects, things beyond routine maintenance. Specifically, we're looking at redoing the walking path around the community park. The concrete is original from 2003 and it's in rough shape. I've noticed. There are some sections that are more patch than original concrete at this point." "Right. So here's my question. Would you be interested in bidding on a full replacement project? It would be several weeks of work, proper compensation, all above board. The easement doesn't require me to do new construction, just maintenance." "I know. This wouldn't be under the easement. This would be the HOA hiring you as a contractor for a capital improvement project. We'd get competitive bids, of course, but I wanted to offer you the opportunity to quote it." I thought about it. It was a big project, bigger than anything I had taken on since inheriting the company. But I had the equipment, the knowledge, and the time. "Send me the specifications and I'll put together a proposal." "Great. And Yates, I want you to know the board really appreciates everything you've done. Not just the concrete work, but how you've handled this whole situation. You could have made things much worse, but you chose to be reasonable. I just wanted to fix my patio. Howard laughed. Yeah, but you ended up fixing a lot more than that. I submitted my bid 2 weeks later, and after the board reviewed all the proposals, they selected mine. Not because I was the cheapest, but because I had the best combination of price, timeline, and quality assurances. The fact that I had a personal connection to the neighborhood didn't hurt either. The walking path project took 6 weeks. I rented some additional equipment, hired 2-day laborers to help with the heavy work, and personally oversaw every pour. The old concrete came out in chunks, revealing the desert soil underneath. I prepared the base carefully, adding proper gravel and compaction, installing expansion joints exactly where they needed to be. My grandfather had taught me that concrete work isn't just about mixing and pouring. It's about understanding the ground, the climate, the stresses that will be placed on the surface over time. Arizona concrete has to handle extreme heat, occasional heavy rain, and ground that shifts with temperature changes. Do it wrong and it cracks within a year. Do it right and it lasts for decades. When we finished, the walking path looked brand new, smooth and level, with a slightly textured finish that would prevent slipping when wet. The board held a small ribbon-cutting ceremony, which felt ridiculous for a sidewalk, but Howard insisted. "This is about more than concrete," he said when I protested. "It's about showing the community that the HOA can accomplish positive things, not just send violation notices." He wasn't wrong. The ceremony brought out maybe 50 residents, including the young couple with the baby I had met months earlier. People were genuinely excited about the improvement, and several of them congratulated me on the quality of the work. One elderly woman who lived near the park grabbed my hand. "Thank you for this. I walk here every morning and I've been afraid of tripping on those cracks for years. Now I can actually enjoy it again." Those were the moments that made everything worthwhile. Not the legal victories or the vindication against Patricia Carmichael's overreach, but the simple reality of having built something useful that improved people's daily lives. As the summer heat arrived in full force, I found myself busier than ever. Word had spread beyond Sunset Ridge about my concrete work, and I started getting calls from other neighborhoods, other developments. Some of them had easement agreements with my grandfather's company too, and I discovered I had rights in places I didn't even know existed. But most of the new work came simply from reputation. People liked that I showed up on time, did quality work, and charged fair prices. The fact that I had stood up to an overbearing HOA and won didn't hurt my reputation either. By August, I had hired 3 full-time employees and was turning down jobs because we were booked solid. The little cement mixer that had started all the trouble was now just one of 5 we owned, ranging from small portable units to a large towable drum that could handle serious commercial work. Wendy had started helping with the business side, managing schedules and invoicing when she had time away from her tech job. "You know," she said one evening while updating the accounts, "you should probably formalize this. Get proper business insurance, maybe incorporate. It's already a company." Donovan Concrete and Supply. A company that basically went dormant after your grandfather died. If you're going to run it seriously, you should treat it seriously. She was right, as usual. I worked with Marcus to properly reactivate the company, update all the licenses and insurance, and set up modern accounting systems. What had started as me wanting to mix some concrete for a patio repair had turned into running an actual business. 1 year to the day after Patricia Carmichael had first marched into my driveway with her clipboard, Howard Price invited me to a special HOA board meeting. "We want to do something," he said mysteriously. "Just show up." I arrived at the community center to find not just the board, but dozens of residents. Someone had set up refreshments, and there was a banner reading, "Thank you, Yates." Howard stood up and addressed the crowd. When Yates moved into our neighborhood, I don't think any of us knew what we were getting. Certainly, Patricia Carmichael didn't. There were some laughs. But what we got was someone who cared about quality, who stood up for his rights without being destructive, and who has ultimately made our community better. The concrete work he's done, both as maintenance and as contracted projects, has legitimately increased our property values and improved our quality of life. He held up a framed document. "The board wanted to officially recognize your contributions. This is a resolution of appreciation, signed by all current board members and over 100 residents. We're also naming the walking path around the Park Donovan path in honor of your family's work in building this community." I was genuinely moved. I don't know what to say. "I was just trying to fix my patio." "And you fixed a lot more than that," Howard said, "including an HOA that had lost its way." Later, standing by the refreshment table, an older gentleman approached me. "Yates Donovan, I'm Richard Martinez. I was the attorney who represented the developer back in 2003, the one who negotiated contracts with your grandfather." "Really? Did you work on the easement agreement?" "I did. Your grandfather drove a hard bargain. He insisted on that perpetual easement, wouldn't budge on it. At the time, the developer thought it was excessive, but Earl convinced them it was necessary for quality control. He said if he was going to put his name on the concrete, he needed to be able to maintain it properly." That sounds like him. He also told me something I never forgot. He said that in any negotiation, you should try to create value for both sides, but never give away your leverage. That easement was his leverage. It ensured he could always come back, could always protect his work. I thought it was shrewd at the time, but seeing how it's played out, I think it was genius. He was a smart man. He was. And from what I've seen, his grandson takes after him. As the evening wound down and people filtered out, I stood in the parking lot looking back at the community center, at the development beyond it, at all the concrete work that represented my grandfather's legacy and now my own. Wendy came up beside me. "You did good." I just refused to back down. That's doing good sometimes. Standing up to people who abuse small amounts of power, showing that there are limits to what they can control. Patricia Carmichael thought being HOA president made her important. "You reminded everyone what actually matters. Concrete matters. No, you idiot." She punched my arm lightly. "Standing up for yourself matters. Building things that last matters. Treating people with respect matters. You did all of that." We drove home through streets lined with houses that all sat on my grandfather's concrete, past sidewalks I had repaired and driveways I had leveled. Every bit of it was solid, dependable, built to last. The cement mixer was in the garage when we got home, quiet and still, just a tool waiting for the next job. It had started everything, this simple piece of equipment that Patricia Carmichael had decided was unacceptable. But really, the equipment wasn't the issue. Control was the issue. Power was the issue. The question of who got to decide what happened in the neighborhood. And the answer, written into legal documents and recorded in county records before the first house was even built, was that some decisions had already been made. Some rights had already been established. My grandfather had seen to that. I never did finish that original patio expansion, not right away. Other work kept getting in the way, bigger projects that paid better. But eventually, On a quiet Saturday morning in October, I mixed up a batch of concrete in that same mixer and poured the extension I had originally planned. It came out perfect, smooth and level, matching the original work my grandfather had done 20 years earlier. When it cured, you couldn't tell where the old stopped and the new began. It was all just one continuous surface, strong and solid and built to last. Just like the neighborhood, just like the business, just like the reputation I had built by refusing to back down when someone tried to tell me what I couldn't do on my own property. The cement mixer sat in the driveway while the concrete cured, its drum still and quiet in the afternoon sun. Nobody came to complain. Nobody sent violation notices. Nobody threatened fines or legal action. Because everyone in Sunset Ridge now understood what Patricia Carmichael had never learned. Their entire development sat on my concrete, built by my family, maintained by me, and protected by agreements that no HOA clipboard could override. And that mixer, that simple piece of equipment that had started everything, wasn't going anywhere.